Now I can see what a ugly word you are, can be when I receive that email. I never actually thought you go through with it, blah, blah, blah. Who the F do you think you are? Okay. So Ricardo Oliveira versus Cristina Damianti Fornos. Who is here on this case?
Your Honor, Ricardo Oliveira here.
And I'm here, Your Honor, Christina.
Oh, Christina's here. Okay, so that's good. What about your attorneys? You have any attorneys?
No, we don't. She finished her work during the final decree.
Okay, so yeah, I see we've got, you were working with Sundita Singla and she's gone now?
Yes, yes.
All right, very good. So do you have a final decree on, oh, it's the quadro you needed help with,
Yes.
right? Okay, so tell me about the quadro. I know it goes 100% to wife. Have you all had a quadro professionally drafted?
Yes, the administrator gives us opportunity to go online and fill out a form, and it gives us, the final document for you to sign.
Okay, that's helpful. Is there anything else that you need me to do other than sign other than sign off on that? I mean, I don't know that I have to sign off. Is it a final decree you want me to sign off on or what?
The final decree is already signed from,
Okay.
yeah, we just need your help signing the quadro.
Okay.
Because we didn't have it
Yes.
today.
Yeah, it looks like there's an agreed judgment that was filed in this case back on March the 26th of 2025. And then it looks like there was a final or partial final decree of divorce that was signed, gosh, back at the end of March. Is that right?
Yeah, that is correct. And if this helps, on page 25, you see the the place where it's spelled out the 100% on a 401k.
Okay, I'm getting there. Thank you for that. Okay, here it is. It's R4 on page 25, 100% of the funds in petitioners Atlassian 401k plan to be divested, a qualified domestic relations order. Okay, so that's what you're bringing to me today?
Yes.
And I assume that the plan administrator requiring me to sign off on this? Is that what's going on?
Yes.
Okay. All right. So do you have you sent me a copy of this or something to sign? Or I have to have something to sign.
I put
So,
it in a box.
oh, you did? Okay, very good. Well, I not in box right now, but I will check inbox for it.
And Judge, I can move that over as soon as we get a break for you.
Oh,
I'll go
thank
so that
you.
you don't have. Yes, Judge.
Thank you very much, Ms. Dewitt. I appreciate it. All right. We also have here Cristina Fornos. Ms. Fornos, I haven't heard from you. Do you agree that that's what needs to occur, is for me to sign off on the quadro?
Yes, Your Honor. Thank you. I agree.
All right, very good. All right, so your quadro, then whatever I need to grant on that is granted. And there's a place for me to sign on there, Mr. Oliveira?
Correct.
Okay, I'll sign it today and then we'll file it with the court. You all both have your email addresses in here, I believe. And then I will send that out to you all and you'll have a copy. All right, very good. Okay, is there anything else you need today?
No, I want to thank you for doing this.
Yeah.
Yes, thank you.
It's very easy to do these things on Zoom. All right, have a wonderful rest of the day, and I wish you both all the best in this next chapter of life.
Thank you so much. Appreciate that.
You may be excused. Okay. All right, let's go on to this next one here, which is FM 24008168. This is Rodney Pierre Jerome versus Ricardo Rules Oliveira. We're here in a substituted service. Who's here on that case?
Yes. Hi, good morning, Your Honor.
Hello, how are you today?
Doing okay. How are you?
I'm fine. I'm just fine. And let me see. I suspect that you are Rodney Pierre Jerome. Is that correct?
Correct. Yes.
All right. So very good. So if I'm understanding what's happened here is that you were trying to serve your ex with divorce papers. The only thing is that he's in Haiti or they are in Haiti and you cannot get them served. Is that correct? Because of that?
Yes, he's in Haiti. I am here in Texas.
All right.
And yes, and
So you have an email address for him and you know that it works. Is that right?
correct. He's been
Mhm.
communicating with me through that email address. Yes.
Okay. All right. But the problem is, of course, is that you can't just, although it makes sense, we sometimes don't deal in things that just are easy. You have to get a court order in order to serve him via email, right? And that's what you're wanting me to do.
Correct.
Okay. All right. So, and you've been communicating with him, so you're sure that there's no problem with
No,
that.
that email address, no, ma'am. It's
Okay.
working. And I had a previous court hearing for the final divorce decree.
Uh-huh.
And he actually sent me an email on that email address,
Mm-hmm.
kind of like threatened me actually.
Ugh.
Yeah, from that email address. And the judge told me the only way she can proceed with signing the final decree is, for me to have an official paper saying that he will serve with the, the divorce.
Right.
And
Okay.
yes, and so she had asked me to contact the law library so they can advise me on how I can go, the other way around with that. And they advised me to send in a petition to serve him by email, since we've been communicating through emails.
Yeah.
And I did upload a copy of that email that he sent me on
Okay.
Box.
On Box. Okay. Well, let's see. Let's go on and put that in the record. What did you tell me? I really cannot get easily into Box
Okay,
from here. Do you have it where you can share your screen with me so I can see it?
I can definitely pull that up. Yes, ma'am.
Okay.
1 second.
And in just a minute, I'm going to swear you in, so we'll get a few facts on the record about this, okay?
Okay.
I'm looking at your case right here, in the motion for alternative service. Once you get the divorce petition on file and wait, if the law library's helping you, you're probably, it's gonna go pretty easily for you. I mean, you'll get the divorce. Don't get the divorce. You will just have to get it served.
Yes.
And the law library will help you. Okay.
Yes, ma'am. I did. So here was what happened. Since, Haiti is kind of upside down right now, there was
I
not really
understand.
a service.
Mhm.
I had a member of my family that was going to Haiti at the time. I
Mhm.
had the original paperwork signed by me, sent in by that family member, and directly served to him by my family member. He
Mhm.
received the paperwork. I know he received them. But the judge was telling me that's not an official way.
Yeah,
It
you
needs to
need to
be
do this.
official.
Yeah,
Yes.
you're good. Do you have the email from him that I
Yes,
can
I
take a
do.
look at?
Yes.
All right. Once you find that, let me know, and don't pull it up right away because I want to swear you in first. And I have a couple of quick questions for you. Okay.
Okay, I found it.
Okay. Raise your right hand. Do you hereby solemnly swear or affirm the testimony you shall give in this cause be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I
All right.
swear.
Very good. Please state your name.
Rodney Pierre Jerome.
Okay. And are you seeking to serve your husband with divorce papers?
Yes, correct.
Okay. And why have you not been able to serve him with these divorce papers?
I have not been able to serve him officially with the papers because he lives in a different country, and there was no official service between Texas and that country that is currently working right now.
Okay. And if I'm understanding correctly, he lives in the country of Haiti, is that right?
Correct, yes.
And there's considerable, just to the best of your knowledge, is there considerable political unrest in Haiti right now?
Correct, yes.
And you are not able to, and therefore you're not able to get him served with the divorce papers, is that right?
Correct, officially, yes.
Okay, very good. Now, do you have an email address for your husband?
I do, yes.
How do you know that email address is a good email address or that he's receiving documentations there? How do you know that?
because he sent me an email prior to our official final divorce decree, threatened me about, what he wanted, and good luck divorcing him without our marriage certificate. And I do have that email here. So
All
he's
right, may
been
I take a look
communicating.
at that? May I take a look at that email, please?
Yes.
Okay.
All right. Let me share.
She just found it. Okay, very good.
Okay.
All right, so I see an email on here, Miss Jerome, that says, "Hello, Rodney," and you're Rodney, is that right?
Correct.
I received an email with a link in regards to divorce cases. I've told you on the phone I will not be attending this meeting. I assume that was a meeting with the law library?
That was the meeting for the final divorce decree.
Yeah, but with the law library, right?
Correct. Yes.
Okay, now I can see what a ugly word you are, can be when I receive that email. I never actually thought you go through with it, blah, blah, blah. Who the F do you think you are? Okay, so here's my thought on this. Good luck divorcing me by yourself when I don't show up at that hearing today. Well, you know what? He's incorrect in the law. You can divorce someone without them showing up, and that's what you're doing. So this email does prove to me that he did receive a copy of that he is receiving email at that. So I will, but let me ask you real quickly. Is this a true and correct copy of the email that you received from your ex-husband or from your husband,
Yes.
Ricardo Oliveira?
Yes.
Okay. And did you receive this email from him on March the 27th of 2025?
Yes.
Okay, and does this demonstrate in your view that he is receiving emails at the email address in question?
Yes.
All right, therefore I grant your, and do you seek admission of this email into the record so that we have it for future reference?
Yes.
All right, your petitioner, I'm going to call it Petitioner Exhibit 1. It is admitted. Your motion for default your motion to have him substitute service on your husband via email at the address in question where you sent this email is hereby granted. So you are free to serve him with that. The order itself, I think, did you send us a copy of an order?
Which order we are
On the
talking
default, for the default, I'm sorry, for the substituted service, did did you get a law library order to us on that?
Yes, I did file that with the court administrator. Yes, they have that, and it was accepted.
Okay, so it went to the clerk's office. Oh, I see it. It's here in the, it's a motion. There's a motion here. Let me see if I've got the order is the problem here. You don't stress. We're going to take care of it.
Thank you.
Don't be worried. I'm just trying to make sure we have everything we need. Okay, that's a motion for service by email. All right, we'll send it. We'll sign an order on this. Ms. Dewitt, would you please make a note in there for the court to get an order out on this case for Ms. Jerome? It doesn't look like she gave us an order, but we can get an order out on it. Once you have that order in hand, you will need to append it to the substituted service. In other words, you send him the divorce documentation and you'll need to take my order because that's what gives you authority to do it and send it along with those divorce papers. Okay.
Okay.
And the law library, if you get mixed up about this, they can help you with how to get that service done, like what you need to send and everything like that. Okay.
Okay. Okay.
But that's what you'll need to send the divorce papers to him as they've told you to do, plus a copy of my order. Okay.
Okay.
And I have not signed my order yet, but I will. You'll get it later today. All right.
Okay. Thank you.
All right. And
May
it'll
I?
come from the, it may not be later today. I have to file it with the clerk's office and then the clerk's office gets it out. And we're getting pretty close to the Easter holiday. So I don't know what their staffing is like. You might not get it till Monday, but don't send that order. Don't send your sub-service until you have my order because my order has to go with it to him in the email. Okay.
Okay. Thank
All
you.
right. What's your question?
My question was, once I sent in those paperwork to him,
Mhm.
as you advised by email, what
Mhm.
is my next step from here?
Well, I can't really practice law, but I would say check back in with the law library. You have to wait a certain number of days once that, I'm looking to see what you've got. Once you serve him with that petition, it's 60 days is the usual standard for it. So I would, but check in with the law library because I don't know everything there is about their case, but calendar that day, okay? Calendar the day that he has to file, it's called an answer. He's
Okay.
not looking at this email and the profanity and stuff like that. He's not, I don't think he's going to file an answer. All right. So you keep an eye on that day when the answer is due, right? And then if he doesn't file it, then you submit through the submission, and the law library will help you with this, your decree showing that you served him, when you served him, and then then the law library will send your final decree or help you. They won't do it for you. Yeah, maybe they will do it for you. Your final decree to the judge to sign. And then once she signs it, I think this is in Judge Meacham's court. Let me see. Let me double check that for you. Yeah, 200th. Is that Judge Meacham or Judge Mangrum? I don't quite remember which. Once she signs it, then you'll be divorced. So those are your next steps. Get this, me sign the order. You send it the subservice, the documents to him along with my order. The law library can make sure you've got everything you need in that email that goes to him. You wait 60 days. And then when he doesn't answer, then you file your default divorce with the court, and the law library can help you with that. Those are your next steps. Okay. Does that make sense?
That makes sense. Thank you.
You are welcome. Now I did see some pretty threatening language in there. Are you worried about him? I mean, I know he's in Haiti, which is good. Are you concerned about your welfare? Do you think he's going to come back here, or?
No, he doesn't have a way to come here to the US, but he's been threatening my family as well, calling them over the phone
Right.
and making, threats. And so all of that, this is the reason why I want to be,
You want out.
yes,
Yeah.
to be
Okay,
done.
so here's the other thing, but you're working with the law library and they're really good on this. But I want to tell you the other thing. If these threats, if you kind of get to the point where you want to do a protective order or something like that, call the Travis County Attorney's Office, and you could probably, I don't know enough about your situation, but if the threats get such that you're feeling concerned for you or your family, or, if you want to try to stop the harassment, it's hard because it's just a piece of paper and he's in another country, right?
Yes,
But,
yes.
but I'm just telling you that if you need such, you can check in with the Travis County Attorney's Office on protective order material, okay?
Okay, thank you.
But do not, we will get you will get this divorce.
Thank you.
And I'll get your order signed, and then you get all your stuff together on that email, copy of my order, all the documentation the law library said, and then you check with them on how to get that served. I mean, I don't want to tell you how to do something. I'm just saying that's, that's
The proper way.
get that check back in with them and say, I've got an order from Judge Eiserloh for subservice. What next? Okay.
Okay, thank you.
All right, very good. All right, if I don't see you again, Miss Jerome, I wish you all the best in this process, and I pat you on the back. Good job getting out of what looks like a very, very difficult situation. I would say I can also see your ex has got a lot of frustration going as well. It sounds like things probably you thought they'd work out and they didn't. So this certainly is a next step that you're taking. So with that, you may be excused. Okay.
Thank you.
That's
Bye.
good. Bye-bye. Okay, very good. So let's keep a copy of that order, or let's get a copy of that order. We need to draft the order essentially.
I'll
Okay,
get it. I'll get into box, Judge, and get these last couple as soon
that
as we
would
get
be
them.
great. Thank you, Ms. Dewitt. And then, Ms. Bat, please remind me at the end of this to help with those orders, because that pro se did not have an order on her, so that's kind of its own special thing.
Okay.
Okay, let me see if I can get back to Teams. Golly, this screen is huge. Let me try to reduce it a little bit here. I saw that Mr. Aguirre had sent me a text on this next case. Hang on. All right. Very good. Okay. Now let's go back to our first case. Is Ms. Ariel Welch, is she back on with us today? Ariel, are you still there?
Yes, Your Honor.
Did you find your certificate of marriage?
Yes, Your Honor, I did. The marriage date stated on here is September 24th of 2018.
Okay, very good. So that was the date of marriage, and then we already went through the date of separation. Okay, that sounds good. So now we're looking for the motion for default judgment. If you would, Ms. Henson, please update with the certificate of last known address with the email, and then send it to me via submission at 455.submission@traviscountytx.gov. Please look at the local rules because they're going to require that you put all the documents together. Once you do that, then now I will sign off on that decree of divorce. Once I get that in there, we have the testimony now from Ms. Ariel Welch. Okay.
Understood. Thank you, Your Honor.
All right. Thank you, Ms. Welch. You may be excused.
Thank you, Your Honor.
Have it best of luck in this next chapter of life, Ms. Welch.
Thank you so much.
Okay, so now we're going to go to our last case of the day, which is FM 10-004313. This is Amber Nicole Henson, who is both here as the attorney and the petitioner, versus Eugenia Morales and Christopher Trevino. Who do I have here? I know Ms. Henson is here. Ms. Henson, are you representing yourself today?
So, Your Honor, I'm not a litigant in this. I'm an attorney. I'm an attorney on this matter too. I represent Miss Eugenia Morales.
Ah, that's the way I was very confused about that. I mean, you just can't imagine how confused I was.
I understand.
I'm so glad that you're an attorney in this case and not the attorney litigant. Now, I know it seems a little unusual, but we do see, and it's
happens.
not that uncommon
I
for
know.
attorneys to be representing themselves. And I don't think it's a good idea, especially to someone who is respected in the court and well liked. But it happens, right? So I was, if it happens, we're going to be here for you. Of course we are, but I'm so glad that you're attorney and not the litigant. Okay, I feel better. My blood pressure just went down. Okay, very good. Now, tell me what this is, because my docket sheet, I think, is a little bit messed up. Whom do you represent, Ms. Henson?
I represent Eugenia Morales, who's the respondent in the action.
Okay. Hang on, let me just update. Respondent. Okay. And who's here on behalf of petitioner?
Your Honor, May Yang of Provost Law Firm.
Ms. Yang, and whom do you represent?
Christopher Trevino.
Okay.
And Your Honor, the Office Attorney General is here too. Daniel Nelson.
All right. Hello, Mr. Nelson. Are we on the record for this? I assume we are. Are we on the record? Who wants a record?
I'm writing, Judge. I'm sorry. I was trying to hit my space bar. I've been writing since you called the case.
No, thank you for that. I think it's a good one to put on the
Yes,
record.
Judge. Yes,
It's a
Judge.
pretty old case. All right, very good. So this was set by the respondent, Ms. Henson, on behalf of Eugenia Morales. All right, let me hear briefly from respondent is by way of kind of a brief opening statement as to what you're seeking today. And then I'd like to hear from petitioner. All right.
Your Honor, this is actually Miss Yang actually set this hearing initially on a motion to enter an order that based on a Rule 11 agreement the parties reached in 2023. Then I subsequently filed a motion to essentially set aside that Rule 11 agreement and a motion for withdrawal of counsel.
Okay, very good. All right, Ms. Yang, tell me what your views are on this case.
Well, Your Honor, unfortunately, it is flustering. I did file a motion to enter. It was by agreement by opposing counsel and I. We've been struggling with trying to get this entered. Rule 11 on final terms. We negotiated very hard, actually, on the doorsteps of the courthouse. We got kicked out of the courthouse, was there till 8 p.m. negotiate. That's how hard we worked with our clients. It was the day of a final setting. We were told to come back the next day. Ms. Henson and I decided, let's take that opportunity. Let's work with our clients. We worked really hard till 8 p.m. that night, doorsteps of courthouse. We filed the Rule 11. The parties have been working under those terms since 2023. It's been a bit difficult for us to get everybody on the same page to get a final order before Your Honor. Eventually, we involved the Attorney General because they are a third party interested third party as well. That took some time. Once we got everyone on close as we could on the same page, I went ahead and filed my motion to sign. And as Ms. Henson mentioned, subsequently, she signed the motion to vacate or set aside, informing me that her client had withdrawn her consent from the Rule 11. I am aware of what that withdrawal of the consent permits Your Honor to do. But I just want the record to reflect that this is a Rule 11 agreement that's been in place since 2023. The parties moved forward and worked under it. The first time I heard about the withdrawal of the consent was on April 4th. A motion was filed, but it actually wasn't filed officially till April 11th. So that was then my first official, exactly what was it? And that was when I was informed it's just not workable. Ms. Henson did also state in her motion that not only are they revoking the consent to the Rule 11 agreement that was entered into in 2023, they are also revoking the consent to the Rule 11 agreement that was entered into 2018 that specifically dealt with the health insurance, medical support. And part of what the AG is really concerned about because we all agreed to wait till final order for purposes of judicial efficiency and cost for the clients. AG had agreed to, on their system, they still show that my client has medical support, but based on that Rule 11 agreement from 2018, we all agreed that it would switch, and AG willingly they continue to do their stuff, which is garnish as necessary, but they agreed to put a financial hold on those garnishment until we could get a final order. So then they can do their system and work with that agreement and be able to release the funds back to my client, which is due my client. But now with the revocation, it's causing a lot of these chaos. So I can't tell you what not to do with the revoking of the consent from the Rule 11. All I am asking is that if you're inclined to accept that revocation and not enter a final order today, I am asking at minimum to allow the AG and have an order that directs them just to continue to do the financial hold until we can get a final order in place on that particular health insurance. And then, of course, that just means the rest of the terms of the case remains open, and I want a final setting as soon as possible. This case has been sitting on the court's docket since 2017. We need to get it finality, not only for my client, but for the child. I'm the attorney that started from day one when we did this modification in 2017. Child was 7 years old. Child's going to turn 15 in August. We need finality.
Right. Okay. And who's here? Mr. Nelson, do you have anything to add to what Ms. Yang just provided?
Your Honor, we're just hoping for a final order. This case, as you mentioned, is pretty old. We have an amount of funds on hold while we're waiting for the court to enter an order with obligations so that we can direct the money properly. The only thing I would add is that in order for us to direct the money properly, we do need a final order with obligations that direct us where to send the funds. The court cannot, the trial court cannot order us to what to do with the money on hold until then, given that it's an administrative function, as Ms. Yang was requesting. But once we have a final order with clear obligations, we can put that on the system. We'll release the money, and the money will disperse as the court ordered obligations require us to.
Okay. All right. So Ms. Yang, your suggestion then, if I'm understanding you correctly, was to allow the Attorney General's office to continue with the hold on funds for health insurance. Is that what you said?
Yes, Your Honor. Or I think in this case, to be more precise, since it seems that the revocation is happening on all terms, more importantly, just any funds that the AG currently have on hold, that it just continues under their administrative order, and then that they will just agree to continue hold until they get further final court order telling them where to disperse, who to disperse. Am I correct by stating that, Mr. Nelson? And,
Uh,
and if that's how it can be stated, I'm perfectly fine with that.
Okay.
So,
All right. Okay, so hang on one second. All right, folks, so here's my thoughts on this. This case is older, as I think every single one of you all have pointed out to me. It looks like Miss Henson she's wanting off this ride. Um, and it has been a merry-go-round, that is for sure. Maybe not a not merry-go-round, more like the wheel of misery.
yeah.
I do think that in terms of we do need to get a final. Here's what I know. I know when we have conflict, and I can see Mr. Trevino, this is wearing on you. When we have conflict, a final order is often the way to kind of still those waters, and we don't have one here. We've got a Rule 11, which is essentially a contract between the parties. For this type of matter, it is revocable. And I think that Ms. Yang brings up a very good point here, which is we don't even know which terms are still the parties haven't agreed on. It sounds like the attorneys worked hard, crafted an agreement that was at least acceptable to these parties some years ago. Now it looks like Ms. Yang that all of the cards are up in the air. We don't know which terms are acceptable, which are not, which means we almost need to get back to, unfortunately, where you all were on the courthouse steps and set this thing for a final hearing, which is a bummer, because that's going to take, you're going to have to prove a divorce. So, and I don't see wife here, or ex, I guess on the SAPs here. I don't see mother here. So, I'm sorry, it's on the SAPs here, it's not a divorce. We just need the final. So here's my thought. I like the idea of setting it for a final pretty quickly here. I really do. Just getting it set with the court as quickly as we can. I like Ms. Yang's idea of letting the AG just kind of continue collecting until they know where the money's going to go. I like that. I think that's all really good. I wish I could see another way other than setting it for a final, but sometimes that's really what a case needs. And I think this case probably does need that, a final hearing. So let's think about that for a minute. So here's a couple of ideas on how to do it cheaply. Excuse me. Excuse me. Sorry about that. I get a sip of water. I'll be right back. Let me just get a sip of water. So if you all do set for a final, one idea would be to try to set it back on Zoom again. But, and I can't preferentially set it with me, but I could ask Mr. Stokes if he could find me or some other judge amenable to this. We could come back on Zoom, but have it projected in the courtroom so we're not on YouTube like we are right now. But with the doors open because it complies with open courts, that will give these parties a little more privacy, because it does strike me that that's probably going to be a little bit of an issue here. But you would have the cheapness of Zoom still, which is helpful in its own way. You don't have to pay for people to drive to the courthouse. So that's one idea I have. I'm sure going to miss Miss Henson's smiling face on this case. But I suspect that she has some of her own concerns right now that are substantial. We'll hear from you in a minute on that, Ms. Henson. Ms. Yang, how quickly, if we were to move to a final, how quickly do you think we could, because you all never had a hearing on this, right? There's not been a final hearing on this.
You're right. So Ms. Morales was pro se from the beginning. Ms. Henson actually came in kind of late in the game.
Mhm.
I was dealing with Ms. Morales for almost a good 3 years before Ms. Henson stepped in, which I was so thankful because it's always difficult to deal
Very
with
difficult.
oversight. So I had set this for a final setting almost 3 times, 3 separate times, and we kept having to continue or pass because I was dealing with the pro se. Luckily, Ms. Henson stepped in. That's why we worked so hard on that Rule 11, willing to sit till 8 p.m. So we've tried. So yes, I would like Your Honor to give me a final setting. I can certainly look at my calendar right now to make sure I don't have any conflict.
Right.
I do want to bring to the court's attention that it doesn't help that Ms. Morales is not on today's Zoom, because one thing I did want Your Honor to question her if she was present was whether or not she intends that once Ms. Henson comes off the case, if she intends to get new counsel, because in this pending litigation, when she was pro se litigant, I did receive death threats that had
Oh my
caused the
gosh.
communication to go further down. And there was a pending criminal prosecution at that point, which is why it further delayed us moving this case forward as quickly as possible. So I will say, if Ms. Henson is granted her withdrawal, which I'm not opposing because I can understand her position, but I am wanting the court to recognize that my communication with her, if she continues as pro se, is going to be very limited, only to the point of providing e-service on pleadings and notice of hearing. I certainly do not welcome that death threat, and I'm going to be very frank with Your Honor. It triggers me every time when this case
God
comes up.
bless you. I'm sure
So-
it does. Listen, we didn't sign up for this, right?
Right.
We didn't do that. I mean, we get ugly threats here in the court too, and none of us signed up for that. I think it's just time to go on and get that final in place. I suspect that we probably, let's not overthink this, right? I mean, I suspect that we can get it done. So here's what I'm going to do. I've gotten with Mr. Stokes. He's here to stand by. Let's set it. As I said, it may preferentially set with me, not officially, but kind of unofficially, just because I'm sitting here helping you and trying to figure out a day to get you into the courtroom. But it's going to be on Zoom. There is nobody coming into this courthouse with death threats on their mind. Okay, that's not happening. So Ms. Yang, that should be some reassurance to you. At least it will be on Zoom. Furthermore, if we need to go down the protective order road, we can do that too. I did see that there was one in the file already. I think Mr. Trevino file, that's already been signed. So, and I like your idea of, until we get that going, just continuing to handle the funds as you suggested, so that the AG is continuing to collect the funds. And as soon as we know where they're going, then sending them there, right? I think it's a good idea.
Your Honor.
Mm-hmm.
And just clarify, the court can't enter orders as to whether or not we withhold funds, but we will keep that hold in place until we get a final order.
Okay.
And we are especially hoping for that to occur soon, because we want to get those funds off our books. But we will not be, the money we already have on hold will remain on hold until we get a final order.
Okay. All right. Very good. All right. So sorry, Mr. Trevino. Yeah.
There's also the matter of, yesterday was tax day and we just filed our taxes again. So the funds that are on hold currently, but there's also another chunk coming that's about to get garnished from our tax return that we just filed. I just wanted to make the Attorney General's office aware of that as well. I don't know how that affects that one that we just filed as well, but
Who's we in this, Mr. Trevino?
my wife and I.
Oh, current wife.
Yeah.
I'm sorry.
I was never married to Miss Morales.
I see. Oh, okay. I didn't understand that. Okay. Gotcha. All right. Okay. So let's go on and get this. I don't know. That's not the only thing I'm trying to do, is to get a final in this case, because final orders will calm the waters. That is the prevailing wisdom in the courthouse. Ms. Yang, when would you like me to try to get this set?
Your Honor, I have the whole month of July wide open. I also have the whole month of August open. So if we can pick one of those dates in July or August, I think there's sufficient time that I have no conflict to where I can say, oh, can't do it. I do believe if we do this hearing, it's going to be more than 3 hours.
Yeah, I believe so too. So let's think about it. So we're in the middle of April, May, June. So I personally go off family in June, at the end of June, but that doesn't mean another judge can't hear it or that we can't, if Mr. Stokes wants to send it back, we could do that. The main thing is though, it's got to be on Zoom projected in the courtroom because of the safety issue. That's the main thing. There's two-way, there's the privacy issue. So YouTube is, I don't think is sufficient for this case. And then over here is the safety issue, which is that we don't want someone who's doing death threats coming around the courthouse in person. That's not going to happen. All right, so let me find out. Okay. So I'm getting with Mr. Stokes. Give me 1 second.
Judge, you mentioned June. I do have the very last week of June available, if you're also available then.
Yeah, I am available at the end of June. Let me eyeball I know I've got to be, I've got a conference in June, but I think I'm back. I think it's earlier in June. I think I'm easily back by that last week. Hang on.
It looks like you're back the week of the 23rd.
Okay, so yeah, so then that means that we could conceivably do sometime that week of the 23rd under the terms that I've just set. So hang on a second. Let me get back with Mr. Stokes. Mr. Trevino, is that going to work for you?
I'm ready whenever
Okay.
the earliest possible date is.
Okay.
Everything, this is the most important thing going on.
I understand that.
And I appreciate the consideration on the off of YouTube.
Yeah. How long do you think this is going to take, Ms. Yang? Do you want me to try to get a full day if I can?
Yes, Your Honor, that is what I announced to last time as well, a full day.
All right. I just reached out to Mr. Stokes. Let's see what he says. And Ms. Henson, I haven't forgotten that you want to withdraw. So let me finish this and we'll come back to that, okay? He's checking. Mr. Stokes is on it. Give him a second here. All right. Let me see here. All right. Not hearing from Mr. Stokes. Guys, I'm sorry. Okay, here's my thinking on this, guys. What Mr. Stokes is recommending is that we set it on a Monday, and that Monday would be June 23rd. How are y'all feeling about June 23rd, Ms. Yang?
Judge, that would work for me that week.
All right. What about you, Mr. Nelson? You good with June 23rd?
We can have an AAG available that day.
What about you, Mr. Trevino?
Yes, that's fine.
All right. So I don't know if he'll be set with me or some other judge. I kind of suspect it'll be set with me just because I've been talking to y'all about it. But our plan is it's going to be all on Zoom, right? So any notices that you send out, make sure it says that. But what we're going to do is we're going to project it with the doors unlocked in my courtroom. That way it helps Mr. Trevino. And it's obviously been a very high conflict matter that's been out there for a number of years. All right. So that's when it's going to be set. Everyone make a note of it. And I'll send out an order setting hearing. So Ms. Bat, if you would make a note that we need to draft an order on that setting hearing. Okay. Now, and it'll be for June 23rd. It'll be announced Monday and it's a full day. I don't know that it's honestly going to take a full day, but it may. And what it looked like to me, Ms. Yang, is that the Rule 11 agreement had kind of a step up type provision for mother. And I would suspect, based on what we're hearing today, that there were hopes when that Rule 11 was entered into that mother would be able to step up, but it seems like, unfortunately, maybe that has not been the case, and there have been some further degradation to her mental, physical health. I don't know anything about her, but things have not gone as we hoped they had gone. So I don't know, but that's just what it's looking like to me since she's not here, and we're having reports of death threats from a member of the bar. Okay, so but we'll see, and I'm certainly want to hear what's going on with her on that Monday. Okay, June 23rd. Now, Ms. Henson, motion to withdraw you have set for today. Tell me why you wish to, we have a trial setting in this case. We sometimes don't let people withdraw so close to trial setting, but I suspect you're having some difficulty with your client. What's going on with that?
Well, Your Honor, the primary reason for my request to withdraw is that my representation of Ms. Morales was limited in scope. I was hired to represent Ms. Morales at the final trial setting that we originally had. The scope of my representation ended when that order was drafted. And quite frankly, that's been the scope of my representation. I've addressed that with Ms. Morales, and she's essentially expressed the desire to represent herself at this point. I do not know that she has the ability to retain additional counsel or to continue with my services beyond the current scope of my representation.
Okay, very good. All right, your motion to withdraw is granted. You would need to send me an order on that. And I will
Understood.
expect it by 5 o'clock today. Send it to 455.submission@traviscountytx.gov.
Yes, ma'am.
Okay, very good. So that's our little plan going forward. Okay. And Mr. Trevino, I know that you're in a difficult position, sir, but I will say that there is something about a final order that sometimes does still the waters. So let's hope that that occurs. Ms. Yang, I will get out the order setting hearing. It will be on Zoom. So any witnesses that you all plan, make sure that you have them ready and make sure that you're very familiar with screen sharing, because we can't, it's not my business to pull your exhibits out of box. Make sure they're all marked correctly and that they're available to share on screen. And don't forget, even though you put them in box, they're not admitted. You're still going to have to ask me to admit them. Okay. And you're going
Your
to
Honor, if
not
I can make one request,
Yes.
when Ms. Hinton sends in her order granting the withdrawal, if she would kindly please put in there the current address and the phone number and email for her client, since who's going to be representing herself, because I do not believe I have any accurate information for her at this point.
I would need that because if you would, yes, Ms. Henson, can you do that to the best of your knowledge and ability?
Yes, Your Honor.
All right, Mr. Trevino, have you had any contact from Ms. Morales recently regarding her current contact information?
Not recently. I believe that I have an address, but I'm not sure if it's still accurate or not. We only communicate through app close.
Close.
Yeah. And it's pretty limited at that, considering there was a protective order and threats were made to my daughter and wife and family as well. So haven't really wanted to have conversation more than
No.
just, you know.
Nor am I suggesting that you do. I just thought you might maybe know where she is.
Yeah.
And it sounds like Ms. Henson is the best source on this. So Ms. Henson, when you draft that order, or if you would please put that information in there, or at least get it to Ms. Yang in some other fashion if you don't want to put that in a public document, so that she is able to get in touch. Okay. All right. Very good. Well, right now, unless something changes, we'll set the order. You're going to be in my courtroom 455th, Monday, June 23rd at the 9 a.m. docket for an all-day setting for a final order in the SAPSIR. We will be looking at all those issues that are in the Rule 11. Okay. Yeah.
Thank you, Your
Right.
Honor.
And please, would someone, Ms. Yang, please reach out to Mr. Stokes? I mean, because I'm just telling you this, but usually judges don't set stuff, and I don't know. He might have something else for me that day, and you'll go to another judge. But he knows the terms that we set forth here, and our terms are: it's going to be on Zoom and it's going to be projected. Okay.
Yes, ma'am. I will do so.
All right. Very good. All right. Is there anything else that we need to, Ms. Henson, send me that order? Anything else that we need to address in this case?
I don't believe so, Your Honor.
All right. All right. Ms. Yang, anything else?
No, Your Honor. I think we've addressed everything.
Mr. Trevino?
No, it's fine. Thank you, Judge, for listening.
Mr. Nelson?
Nothing else, Your Honor. Thank you.
All right, very good. You all may be excused, and in all likelihood, but Ms. Yang, don't forget to call Mr. Stokes.
Yes, ma'am.
Don't forget to call him.
Yeah, I
That
will
could
do
be
so.
bad. I don't want to get in trouble. Really, I don't. All right, very good. We'll see you all on